Welcome to Human Resources for the People. It's a human capital revolution. If you like what you heard today, please like, share, and subscribe for more content about people-centered HR. Today on Human Resources for the People, I'm going to talk about this new article coming from Shawe Rosenthal, LLP. It's from their labor and employment report. It's an excellent resource for those of you who are wanting to learn more about labor law. And the title here is Employers Don't Automatically Assume Prescription Meds Pose a Danger in the Workplace. I've made this mistake before, and I've had employees make this mistake before. So let's take a look at this article and see what they have to say. We're going to talk about a recent case that came out here. And what's interesting, so HR managers have a very difficult job balancing two demands that come up pretty frequently with respect to prescription drugs and employees. When they're in safety sensitive positions in factories and so forth, you have to be careful that the employee is protected, that the people around the employee are protected, as well as protecting the employee's rights to accommodation and disability management if it comes up. And that's what we see here. So in Bird versus Utokumpo Stainless USA, a person applied for a position in the melt shop of a steel mill. And this position was deemed by the company as a safety sensitive position. And this person tested positive for hydrocodone. They had a prescription for it, of course, um, but they considered the position safety sensitive. And as a result, were concerned about this employee working around heavy machinery and so forth in a steel mill on hydrocodone. And they decided not to hire the applicant. Now, the applicant sued as a result of this, as a result of not getting hired, and this posed a big issue, right? The EEOC claims that you do not have to employ someone in their position if it poses a direct threat to themselves or others around them. However, it can't be speculative. And this is something that I've struggled a lot with in my career because there is those managers who are really willing to be scared of a particular prescription drug, a legal prescription drug, of course, because of the safety threat that it poses, not willing to listen to this person's rights within the workplace and within the Americans with Disabilities Act. The prescription or the accommodation can't pose a significant risk of substantial harm, and it has to be based on objective factual evidence. At one time I had an employee who was moving very dangerous materials around and was taking a mind altering drug. And the company policy was to not allow them to take that mind altering drug while holding that position. It turned out that that drug that the person was prescribed for did not actually pose a significant risk of substantial harm because that person had been taking it for a significant amount of time. And as a result, HR managers and employees alike have to consider this kind of tight balance. The company in this Bird case automatically assumed that because the employee used a hydrocodone prescription, they automatically posed a safety threat, and that was it, that there was nothing else. However, the person posed no real threat. They didn't consult with the person's doctor. They didn't, the nurse who made the decision didn't really understand hydrocodone and consistent use of it, as well as they didn't actually check to see if it posed any risk to the employee or the employer. And that's what's critical when you're understanding ADA and prescription drugs. The employer has to make these considerations. Great article from Shaw and Rosenthal gives a couple different options for employers and employees alike when working through these difficult situations. You know, the article throws out there that you should make sure that you're actually evaluating the employee's responsibilities. You do that by making sure that you're actually fitting it with the job, right? A prescription for hydrocodone is not on its face very dangerous in the world of office work, but it does matter or could matter with manual labor. In addition, you want to work with their doctors to go through the interactive process and making sure that an employee is able to perform the essential functions of their job, regardless of whatever prescription that they're on. A person, and it notes here that a person may experience effects that another person may not, and that's an important distinction that people understand. In addition, if employees are taking it like at night or something like that, where it has no chance of imperiling the employee's coworkers or the employer, that is also a consideration that we have to make. Finally, we had to confirm that there aren't alternative reasonable accommodations to a prescription medication. So to wrap this up really quickly, as HR managers, employees, we have to consider these topics and don't just simply blanket ban. And as employees who have prescriptions, make it very clear that uh, you can do the job, and you might want to make sure that you're documenting it when you're going to an employer and explaining what you do. If you decide to take suit against the employer in the future, that documentation can become very valuable. Well, that's it for me today here on human resources for the people. I hope you enjoyed what I had to say. And as always, if you enjoy what we had to say, like, share, and subscribe, and I'll see you on the next video. Thank you.